As foreshadowed in episode 2, today's episode will look again at the case of Mr. Beeling, this time in detail at the VCAT decision and penalty orders, as there have been no further publications on this case, but it remains a conceptually interesting matter. First, I will explain the details of the charges and the penalty. Secondly, we're going to examine in detail one of the 9 proved allegations submitted by the Victorian Legal Services Commissioner, a draft statement of claim with serious deficiencies. Finally, we will discuss Mr. Beeling's approach to ethical decision-making and draw out some conceptual ideas. Part 1. The charges and the penalty. In November 2017, Mr. Beeling was found guilty of 1 charge of professional misconduct at common law for failing to exercise due care and competence in his retainer, and 1 charge of statutory unsatisfactory professional conduct under the old Professional Conduct and Practice Rules 2005. A failure to adequately advise the handlers so as to permit them to give proper instructions. Under the Uniform Law, which is now law in Victoria, the equivalent to this is Rule 7 of the Australian Solicitors' Conduct Rules. The first charge, the common law charge, encompassed a greater range of conduct, including the preparation of the draft statement of claim, which we'll discuss later, and appeared to be more about Mr. Beeling's attitude and overall competence. Whereas the other charge, the statutory charge, was specifically related to the failure to provide the handlers with the analysis and advice they needed to understand their legal position. While the conduct around the draft statement of claim was not part of this finding, it was still a helpful example, as the conduct of both charges is inextricably interwoven, and demonstrates clearly the lack of insight which prevented Mr. Beeling from giving adequate advice. As explained in the penalty orders, the most important penalty imposed was a supervision period. The principal reason for supervision, rather than suspension of practicing certificate or recommending removal from the role, is that VCAT identified that Mr. Beeling's conduct arose out of a lack of insight. Legal insight can be difficult to develop as a young practitioner, as it involves a degree of practical understanding in addition to legal technical skills. Mr. Beeling was new to this area of law and relatively inexperienced as a sole practitioner, so despite being admitted over a decade ago, this case offers some important wisdom to young lawyers who may be tempted to take on more responsibility. It is also important to establish that Mr. Beeling was never alleged to have been dishonest or attempting to take advantage of the handlers. Equally, he was not alleged to have failed the standard of diligence either. In fact, one of Mr. Beeling's referees wrote about his dedication to assisting socially disadvantaged clients and sensitivity to client circumstances. This background begins to paint us a picture of how Mr. Beeling found himself in such a difficult position. Part 2. The Draft Statement of Claim. Beeling spent 19 hours drafting this document, which alleged serious breaches of consumer law. Despite this, the document was confusing, repetitive, incomplete, and did not comply with court rules. Despite never being filed, it was clearly intended to form the basis of a formal statement of claim filed in court following the mediation, which at the time was some weeks away, which meant the deciding VCAT officer took the statement of claim very seriously, even in its draft form. The document contained irrelevant references to intimate medical conditions of the clients, inappropriate, emotive, and accusatory language, and an incredible range of allegations, even more diverse than those originally envisioned by the handlers. These faults demonstrate a lack of competence in the technical skills required to carry out litigation of this type as a sole practitioner. However, the most significant deficiency was the lack of articulated basis for the written claims, and indeed the entire case against ANZ, which was a major component of the ultimate adverse finding against Mr. Beeling by VCAT. In the penalty orders, the senior member noted the special responsibility under the Civil Procedure Act for practitioners to ensure the just and timely resolution of real issues in dispute. While it never got to the stage of proper basis certificates, these obligations should inform all legal decisions and communications. It seems that Mr. Beeling may have had some idea of the deficiencies of the statement of claim because he sought drafting assistance from counsel to polish up the document. However, when faced with advice that the entire document needed to be redrafted from scratch and bases for claims reconsidered, he discontinued the brief and never engaged anyone else. VCAT pointed out that this demonstrates his stubborn refusal to accept the deficiencies of his own conduct and lack of insight into the consequences of making such a serious but misguided set of legal submissions. This stubbornness was further demonstrated by Mr. Bealing's complaints against ANZ solicitors alleging flagrant disregard for FMC orders, as well as the corruption accusations he levelled against the Victorian Legal Services Commission officers who were investigating the complaints against him. Part 3. Approaches and Implications. While it is difficult and inappropriate to speculate about Mr. Bealing's motivations, some comments can be made in the context of the 4 ethical approaches discussed by Christine Parker and Adrian Evans in Inside Lawyers Ethics. It seems likely that Mr. Bealings believed strongly in his client's case, sympathized greatly with their personal circumstances, and was seeking, however misguidedly, to expose predatory behavior by ANZ. This is consistent with the moral activist, which is characterized by professional choices motivated by personal ideals. As Parker and Evans point out, moral activist lawyers support important aspects of our legal system, as they may be more inclined to work pro bono to support cases they care about. However, this case unfortunately demonstrates that having a strong investment in a client's cause can make a practitioner lose objectivity, carry out inappropriate instructions, and ultimately fall short of the required standards of competence. Another criticism of the moral approach is that it places commitment to the cause above the client themselves, which may have been partially demonstrated in Mr. Bealing's insistence that the Hannahs keep up the pressure on ANZ rather than accepting realistic settlement offers. However, this is not intended to persuade practitioners, especially younger ones, from holding and in fact acting on strong social ideals. Legal activism motivated by a desire to improve the law is extremely commendable and arguably necessary to keep our legal system developing in all areas. The commercialization of the legal system, development of legal markets, and expansion of litigation funding suggests that marketability of legal services is growing in importance. This presents many challenges to the legal profession, but moral activism may be one way to encourage ethical and just outcomes despite commercial incentives to focus legal representation in areas of high demand. Mr. Bealing's case demonstrates the importance of developing insight and maintaining objectivity, and perhaps in a near future, dominated by commercial efficiency and profits, ethical insight may also assist in maintaining public confidence in the legal profession. You've been listening to Kangaroo Courts, a podcast by me, Theodore Murray. You can find us online at Kangaroocourts.blog and follow us on Twitter at Kangaroo_Courts.